Hi again from Agas. I'm Nikhil, and today we're going to be learning about Chapter 3 of the Mental Health Care Act, which pertains to advance directives. An advance directive, or AD, refers to a legal document that allows individuals to nominate representatives in the scenario where their judgment is compromised due to mental illness. These nominated individuals have the right to take decisions regarding treatment on behalf of the person with mental illness, and they're allowed to do this in the form of writing. This stays in effect until the individual regains the capacity to make decisions. Every state mental health authority should constitute district-wise mental health review boards that are required to maintain an online register of advance directives. The AD shall be provided to the concerned mental health care professional when required. It must be noted that this advance directive does not apply for emergency treatment. The regulations for making these directives are prescribed by the central authority. The individual has the right to revoke, amend, and cancel an AD at any moment. Factors such as having made these directives under influence or coercion, circumstances that differ from what was anticipated when making these respective ADs, lack of information regarding the decision, conflict with existing laws, and incapacity to make decisions are considered here. Every medical officer and psychiatrist in charge of the individual's treatment must act in accordance with these directives, and it is ensured that they have full access to them. In the case of a minor, a legal guardian shall have the right to make directives until the individual attains 18 years of age. The central authority shall periodically review these directives and make recommendations in terms of procedures and regulations. Lastly, the medical officers are not held liable for not following the directive if they had not received a copy of it in advance, or any unforeseen consequences that stem from following it. So here we can see how an AD can be a turning point in the process of treatment. We can reflect on the importance of educating ourselves about various treatments for mental disorders. Our right to adopt a certain treatment must be an informed choice. Otherwise, our mental health care may be compromised. In the description, we have attached a few resources regarding mental health treatment and the available options. Unfortunately, we must inform you that despite coming into force on May 29, 2018, most states have not constituted the mental health review boards, and the portals for registration of ADs are still awaited.
Hi, I'm Darshana from Agas. As we all know that mental illnesses can impact decision making. Thus, a person can entrust another person whom she trusts to make decision regarding their mental health treatment on his or her behalf. Today in this video, I'm going to talk about the Chapter 4 titled as Nominated Representative addressed in MHA 2017. Let's begin. For instance, an adult who is 18 and above who is seeking mental health care admission has the right to nominate a representative by providing a signed consent. Now, what happens if the person has not nominated a representative in the advance directive? In that case, the individual may be represented by a relative, caregiver, or appointed by the director of the board or from the Department of Social Welfare. Now, let me tell you what are the roles of the nominated representative. The decision of a person with mental illness is upheld at any moment, and the nominated representative can be removed by the person or the board at any time. The board may, after deliberation, decide that the nominated representative is unfit. The nominated representative cannot overrule the person's decision but can offer support by making informed and well-thought decisions. The duty of the nominated representative is to seek information on diagnosis and treatment to aid the person and family, to ensure that the rights of the person has not violated and proper rehabilitation services are delivered. Let me tell you what happens in the case of minor. The minor who is 18 and below is seeking mental health care admission. At that time, the legal guardians are their representative. But if the board of deliberates finds that the guardian is unfit, then it can nominate another individual. Also, in case if there are no legal guardians, then the representative is nominated by the Department of Social Welfare as their nominated representative. Now I will be talking about the practical implications of this chapter. The central and state authorities are further required to ensure easy provisions to the necessary forms while making an advance directive. For example, the Delhi government's State of Mental Health Authority website has easy access to a series of forms such as application for access to medical record, application for access to admissions such as independent admissions, admissions of minor, admissions which require high support, and admissions who request for continuation of admission. Furthermore, these forms also provide healthcare workers who determine severity of mental illness. To conclude, I hope you all have understood that what exactly is a nominated representative and why it is important. Therefore, whenever you come across to these situations, please make sure that you appoint the right person as your nominated representative. Thank you.